Hi, my name is Greg Maxwell, and in this training, I'm going to share how employment attorneys can dramatically increase their clients' after tax net recovery and protect themselves against a malpractice claim. Look, as a fellow attorney, I know that you're busy, so I want to share my two goals for this training right up front. First, I'll discuss a powerful tax planning strategy that significantly increases your client's after tax net recovery by lowering the total amount of taxes paid. And the only way for your clients to avoid paying an enormous tax bill is through the planning strategy I'll discuss today. Second, I'll share how this strategy provides your client with benefits beyond tax planning and how it provides you, the attorney, with significant liability protection and peace of mind. And also, at the end of the training, I'll give you details on how your clients can get a free, personalized tax savings analysis that illustrates how much more the client can net from their recovery by using the strategy I'll discuss today. If you are a plaintiff attorney and you help clients in any of the following practice areas, I invite you to focus on this training because it absolutely helps your clients. Employment and labor law cases, discrimination or retaliation cases, whether employment related or not, and whistleblower claims. If you handle cases in any of these first three categories, this specific training is for you. This strategy also works for any other case type where the plaintiff has to pay income taxes on the settlement they receive. But clients in this last category need additional tax strategies that clients in the first three categories don't need, which I'll explain in just a minute. So before we dive into this training, if you handle taxable cases other than employment, retaliation, discrimination, or whistleblower cases, I've created a separate training that contains information about the additional tax planning strategies those particular clients need. You can check it out at amicusplanners.com/taxable. Examples of these case types include financial, tax, and legal malpractice, defamation, breach of contract, and intentional infliction of emotional distress. In addition, any lawsuit that may result in punitive damages or post-judgment interest, including employment cases, needs those additional strategies. Essentially, if the plaintiff must pay tax on the legal recovery and cannot deduct attorney's fees, and I'll talk more about this soon, they need the additional tax planning strategies I go over in the other training. And if you handle personal injury cases, I have a training specific to PI, which you can watch at amicusplanners.com/PI. Having said all that, if you handle employment, retaliation, discrimination, or whistleblower cases, you're in the right place. Okay, so you're probably wondering why I'm qualified to teach on this topic. If you don't know me, my name is Greg Maxwell. I'm a practicing attorney and a certified financial planner. And my firm, Amicus Settlement Planners, works with attorneys and their clients nationwide. We focus solely on financial and tax planning for plaintiff attorneys and their clients. Our team consists of practicing attorneys, certified financial planners, and CPAs. In addition, we recently added the preeminent settlement-specific tax planning attorney in the country to our team. So our firm was created to be the one-stop shop for tax planning for plaintiff attorneys and their clients. And I'm excited to share one of these powerful strategies with you today. So here's what we'll be covering in this training. In part one, I'll discuss the tax problem that creates an enormous financial burden for your clients. In part two, I'll share the proven and powerful tax planning tool that dramatically increases your clients' after-tax net recovery. And in part three, I'll discuss how your clients can get started with this strategy and how you can protect yourself from upset clients and potential liability. And this is not one of those videos where they never tell you what the solution is. I'm going to give you the tax strategy solution in full detail, but we have to first outline the tax problem in part one before we can discuss the solution in part two. So here we go. Part one, the tax problem that creates an enormous financial burden for your clients. In order to understand the tax problem, we first need to talk about the deductibility of attorney's fees in taxable cases. Specifically, we need to understand how the Tax Cuts and Jobs Act made things much worse for many plaintiffs, and why if you're handling discrimination, retaliation, or whistleblower claims, your client is in luck. So plaintiffs have always been taxed on the full gross recovery in taxable damages cases, including on the attorney's fee portion of their recovery. Before the Tax Cuts and Jobs Act of 2017 was passed, individual plaintiffs could deduct the attorney's fees as a deduction on their tax returns. However, now, after the Tax Cuts and Jobs Act, individual plaintiffs cannot claim a deduction for attorney's fees except in specific case types. The major exceptions where attorney's fees can be deducted are discrimination cases, retaliation cases, and whistleblower claims. So your plaintiff is in luck. The Tax Cuts and Jobs Act will not affect them unless there are punitive damages, because you cannot deduct attorney's fees for punitive damages. So if you handle case types other than these limited exceptions, also watch our other training at amicusplanners.com/taxable. So let's talk a little bit more about the problem, which is the client's high tax bill. Even though clients can deduct your legal fees in employment, discrimination, retaliation, and whistleblower cases, they still must pay income taxes on their portion of the legal recovery. This is the tax problem that creates a large tax burden for your client. When clients receive their legal settlement, they often pay taxes at the highest federal, state, and local tax rates. In many states, roughly half of what the client receives will go to taxes. For example, let's assume a $10 settlement, $4 to attorney's fees, and $6 to the client. The client pays 50% taxes on $6, leaving an after-tax net of $3. So a large tax bill isn't the only problem. Many clients are unaware that they'll have to pay taxes on their legal recovery, which can be a real gut punch and a terrible surprise. And being able to keep only a fraction of the settlement causes clients to feel upset, stressed, and often disappointed. And the huge tax bill can result in the client being frustrated and dissatisfied with you as their attorney, which often results in bad Google reviews, fewer referrals, and even a potential malpractice claim or bar complaint. So what's the solution to the client's huge tax bill and all these other problems? The solution is the tax planning tool I'm going to discuss here in part 2. So in part 2, I'm going to share the proven and powerful tax planning tool that dramatically increases your client's after-tax net recovery. The solution to maximizing your client's after-tax net recovery is a structured settlement annuity. So let's explore the solution, how structured settlement annuities work, and why they can be the game changer your clients need. So here's how a structured settlement annuity helps. The best way to reduce the client's tax bill is to spread out the receipt of the settlement recovery over several years by using a structured settlement annuity. Instead of paying a roughly 50% tax rate on the recovery in the year the case settles, with an annuity we can lower the client's marginal tax rate. So by reducing the client's marginal tax rate, the client pays less in total taxes on the recovery. Let's look at a case study to examine how much a structured settlement annuity can save your clients. So let's assume the following assumptions. There's a gross recovery of $5 million, and case costs and contingency fees add up to a total of 40%. So in this first scenario, let's assume there's no annuity. So there's a $5 million gross settlement, a 40% attorney's fee, and let's assume that they're in a 50% combined federal, state, and local tax rate. So that means that the pre-tax to the client is $3 million. The after-tax net to the client, assuming that 50% tax rate then, is $1.5 million in the client's pocket. So that's an after-tax percentage of the gross recovery of only 30% to the client. In scenario number 2, let's look at what happens with an annuity. The same $5 million gross settlement, the same 40% attorney's fee, but rather than a 50% tax rate, because the client received the entire settlement in the year of settlement in year 1, let's assume a 25% tax rate because we're spreading out that $3 million pre-tax net to the client over 10 years in an annuity. So that means the client's still getting that same $3 million after attorney's fees and costs, but they're spreading it out over the next 10 years. So by doing that in an annuity, the after-tax net to the client is $2.62 million instead of $1.5 million. That's an after-tax percentage of the gross settlement of 52.5% rather than 30%. So instead of your clients paying a huge tax bill in the year in which they receive the settlement, they can spread that tax out over the next several years, and they're earning interest on that full amount inside the annuity that whole time as well. So by using an annuity, we're able to increase the after-tax recovery of the client from 1.5 to 2.62 million. More than $1 million more in this example, which is a 52.5% increase to the client. This illustration shows the power of using an annuity. How would your clients feel with an extra $1 million from the settlement in their pocket? Dramatic tax savings to the client aren't the only benefits of using a structured settlement annuity. Let's look at some of the other benefits of using an annuity. An annuity provides a guaranteed, stable, secure income stream that is not subject to market risk and market volatility. Payment streams are customized to the needs and goals of the client, including providing lifetime income if desired. Annuities offer protection from creditors, predators, and bad decisions. Dissipation risk is a serious concern in lump sum settlements. There's a risk that a client who receives a large lump sum settlement might spend the money too quickly or invest it poorly. We've seen this happen dozens and dozens of times. Structured settlement annuities help protect against this by providing guaranteed income over whatever time period the client chooses. Another unique benefit of a structured settlement annuity is that the annuity is funded with pre-tax money and it grows on a tax-deferred basis. The client only pays taxes when the annuity payments are received in the future. Also, the total amount a client receives is greater than the amount placed into the annuity because of the annuity's internal growth. So we've outlined some of the benefits to the client using an annuity, but what about you? What are the benefits to you as the attorney? Most importantly, you'll have much happier clients who are able to keep much more of their settlement in their pockets, And as you know, happier clients leave 5-star Google reviews and are much more likely to refer their friends and share their positive experiences online. So by introducing your clients to these tax planning solutions, you're showing your clients that you care about what happens to them after settlement. And you'll enjoy the peace of mind knowing that your clients won't squander their settlement and that a third party provided them with the tax planning, not you. So you get liability protection for you and your firm. We'll talk more about this later. So now that we've illustrated how an annuity can drastically increase your client's net recovery and highlighted some of the additional benefits for both the client and you, the attorney, let's go over some frequently asked questions we receive about structured settlement annuities. So the first question we often get is, when should I introduce an annuity to my client? We recommend informing your clients about the tax consequences of any potential settlement at the outset of the case. And you can tell your clients right up front that using an annuity may minimize their tax bill. Your client should explore specific annuity options and projections before mediation or arbitration, if possible. So if a client wants to use an annuity, often the defendant must agree at mediation or arbitration. So it's essential to know if an annuity is something you want to include in your negotiations. It's important to note that the plaintiff does not have an automatic right to use an annuity. Your involvement and negotiation are required. If a settlement is reached at mediation, you, as the plaintiff's attorney, should request the inclusion of language that preserves the right to use an annuity, even if the plaintiff has not yet decided to annuitize the proceeds. This step is important, as a defendant may refuse to annuitize the settlement even if the parties plan to negotiate a more comprehensive agreement later. So by taking a few minutes to plan now and include that language at mediation, you can save your client a significant amount of money in taxes later on. So if you wait too long, the ability to use an annuity may disappear. So another question we often get is, will an annuity slow down the settlement? There's no reason why an annuity should slow down the settlement process at all, as long as everything is set up in time. If the client chooses to use an annuity, we will provide you with all the documents to be signed by each party. This is a good reason to reach out early so that we can get the ball rolling on the needed documents, language, and signatures. It's important to note also that annuity-specific language we provide must be included in the release or settlement agreement between the parties. And any funds allocated to an annuity must go directly from the defendants to the annuity company. It cannot go to your IOLTA account first. Another question we often get is, don't annuities have low rates of return? Well, rates are higher than they've been in many years, but remember that the main benefits of using an annuity are to reduce taxes and ensure future income. The rates of return are an added benefit, but aren't the main benefit of an annuity. So also with an annuity, the earnings and growth within the annuity are not taxed until realized. The payment streams grow on a pre-tax basis. So annuity rates are relatively competitive when compared with other potential investments, especially given that the income is guaranteed and not taxed until paid. So having said that, there are several annuity types with higher rates of return that we can explore with your clients, including an index-linked annuity with several unique and attractive features. Some of these features include no risk of loss and 100% participation in the underlying index growth with no cap on the upside growth. This gives the client the best of both worlds, no downside market risk and full participation with no cap on the market growth. This particular annuity has been extremely popular with many of our recent settlements because it essentially guarantees that they're not going to lose money, but also allows them to participate as the underlying index grows. Especially if they have a long-term time horizon, these can be extremely compelling. Another common question is, does my client have to put all of their settlement funds into an annuity? No, clients can put as much or as little of their settlement into the annuity as they want. Obviously, each client's situation is different, and careful planning and forecasting needs to be done to build an annuity that minimizes taxes and plans for that client's unique cash flow needs. Another common question we get, especially in employment cases, is what part of the settlement can be annuitized? So in employment cases, nearly any recovery amount for items other than lost wages can be annuitized. Wage-related settlement proceeds are treated as W-2 income and are subject to withholding, FICA, unemployment, and disability taxes. So as a result, wage-related proceeds cannot be annuitized. In other case types, up to 100% of the client's recovery can fund an annuity. So another question that we get asked in a variety of different ways is, am I liable if I don't tell my client about an annuity? The ABA Litigation Committee has stated that competent representation of plaintiffs requires informing them about the tax implications of the settlement. So if you don't tell your client about this issue and they find out later how an annuity could have saved them on taxes, it will be an awkward conversation at least and a potential malpractice lawsuit. But look, we're here to protect you. Getting tax planning advice from a third party provides you with significant liability protection and results in much happier clients. And we realize that most attorneys do not want to give tax advice. That's why we're here. So now in part 3, I'll show you how to get started with this strategy and how to protect yourself from upset clients and potential liability. So how do you get started? Step 1, schedule a phone call with me to discuss your case or your practice. Step 2, we'll determine if an annuity will help your particular client, and we'll prepare a comprehensive analysis of the potential tax savings for your client. And then in step 3, you do what you do best and get the best possible recovery for your client. We'll work with your client to reduce their taxes and create a plan that meets their needs and goals. So for everyone who books a call with me, my firm will meet with your clients to prepare a customized tax savings analysis at no charge. This analysis shows your clients exactly how much they can save by using an annuity and outlines several annuity options to fit their needs and goals. So many factors go into developing the perfect plan for your client, including their marital status, their historical income, the state of residence, their future needs, goals, their expected income and expenses, and more. It takes extensive tax and financial planning expertise to navigate each client's unique situation, which is why we've built our team to be the one-stop shop your client needs to evaluate their options. So even if your clients decide they don't want to move forward and implement the tax saving strategies we outline, your client gets to keep our analysis and you get to add it to your client's file as invaluable CYA if they ever come back and complain about how much they paid in taxes. We're so confident that we can help your clients save a significant amount on their tax bill that we're willing to create these customized financial plans at no cost. So you don't need to remember all of this stuff that I've covered today. Our firm works best as your firm's tax planning partner. You can simply tell your clients, don't worry, we have a tax planning partner who will do the tax planning with you. And when your clients know at the outset of a case that you have a tax planning partner that will walk them through all of their options and provide them with the tax planning they desperately need, this is a great selling point for your firm, and it gives your clients significant peace of mind. Not only that, by bringing our firm in to advise your clients at no cost, you get valuable, free liability protection. And look, your client has gone through something traumatic and terrible. They've been discriminated against, retaliated against, they've been fired from their job, something terrible has happened. And now they're going through the difficult, emotional litigation process, which is not easy on any client. We love providing them with the good news that when the case settles, they can save a bunch on taxes. But it's more than that. We love being able to help clients enjoy the peace of mind that comes from having a carefully crafted plan for their settlement proceeds that both minimizes taxes and provides for their future needs and goals. This is our mission and our passion. So again, the next step is to book a free 30-minute call with me. If you have an existing case, make sure to book a call now because the clock is ticking if your client will benefit from an annuity. If you wait too long, this option may not be available to your client. And even if you don't have a currently pending case, let's get on a phone call now so you can know what to do when your next employment or whistleblower case comes in the door. To book your call, first click on the button next to this video. It will take you to a page that looks like this. Then choose the day and the time that works for you. Once you've selected a date and time, enter your name, email, and phone number and click Done. You'll receive a calendar invite via email, and I'll call you at the phone number you provided when it's time for the appointment. So again, let's get on a phone call to ensure your clients pay as little taxes as possible. Here's my promise. If my firm can't help your client save on taxes, I'll let you know that right up front. This is not a high-pressure sales call. I'm a fellow attorney, my time is valuable, and your time is valuable. The strategies I've outlined today have worked for hundreds of clients we've worked with nationwide for the past 20 years, and I'm confident we can help your clients as well. So click the button on this page now to book your phone call. I look forward to speaking with you soon.